Hello, and thank you for joining us today on the Ask Andrew Show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the principal of the Greater Toronto Area family law firm, Feldstein Family Law Group. Both myself and the entire firm practice exclusively in the area of family law. Today, our special guest is Dr. Barbara Landau. Dr. Landau is a mediator and arbitrator. She's recognized for her many achievements, and to name a few, she's been acknowledged for her dedication and screening for power imbalances and domestic violence and family mediation, as well as her outstanding contribution to clinical psychology. I should add, I have also taken Dr. Landau's course on arbitration a number of years ago, and I've taken her course on screening for domestic violence, and we've had many discussions about some of the topics that we're going to discuss today. And today, our topic is domestic violence, and I think what flows from that is power and control. So thank you for joining us today, Dr. Landau. And I wanted to start by saying, as I said before, you've had a dedication of screening for power imbalances. Can you explain what that is?
Well, I think that in family breakup situations, there's a concern that at that time, there's a real rise in domestic violence issues. If someone is unhappy about the marriage ending, they often start to work to prevent that reality from happening. So what we're trying to look for is, first of all, everybody's safety. That's the safety of the abuser as well as the person who is the victim of abuse, as well as the children in the family and maybe extended family members. And so what we're looking for is whether people are capable, whether the situation allows for them to be capable of making decisions with each other. Can they make decisions where they have the freedom to disagree? They have the freedom to put forward issues that reflect their own interests and maybe the interest of other family members. And are they able to take action to actually move the separation along in a fair and reasonable way? And that's what we're searching for. We're searching for safety, fairness, reasonableness, the ability to understand, the competence to understand the kinds of decisions they need to make.
Okay, so in what cases would people screen for domestic violence? Would that be in every family law case?
I would think every family law case should have a screening for domestic violence. What you're screening for is really the principles of contract law. You know, Andrew, about the principles of contract law, that you have to have the capacity to make, to be informed about the information, to be able to make a decision without duress. And so we're really looking to see whether the principles of contract law, the capacity to negotiate a fair and reasonable agreement, is possible. And since family law is all about negotiating agreements, we need to know whether that facility is there.
Well, would I be correct in that there's a statutory mandate that you have to screen all cases for domestic violence when there's an arbitration, but there isn't a statutory mandate anywhere else in family law? Is that right?
There isn't a statutory mandate. There is now in British Columbia a requirement on all family professionals, and that's a pretty wide swath of people, counselors, lawyers, mediators, everybody that's involved in helping a family get through a separation now has to screen. And they have to screen for the kinds of principles I talked about. Are people safe? Are people able, do they have the capacity to make decisions? And the purpose of it is to then be able to have a conversation with people about what process is likely to be best for them. And that includes everybody. So I like the BC new legislation that came out a few years ago. And in the new legislation that we're going to have, the Divorce Act, there is going to be a requirement that people take that into account. I don't know that it'll be as broad as the BC, but it's pretty close.
Okay, and I guess the big question will be whether or not the amendments to the Divorce Act will end up being proclaimed into force before this government has an election and determine.
My hope is because the amendments that have been proposed are virtually the same as those proposed 20 years ago. Because I testified before the Joint Committee of the Senate and the House of Commons then, and I did again now. And they're the same with some improvements, but it's basically many of the same concepts.
Well,
What they've added on is more of an awareness of domestic violence issues. That's the one that I think deserves some certainly to be taken seriously.
Okay. I think everyone agrees that we have to take things seriously, as well as the fact that we need to have safety and security for people. But the distinction that I'm trying to deal with right now is that, at least in Ontario, as the law currently stands, there's an obligation to screen for domestic violence in arbitrations. I would agree with you that in mediations, there should be screening, but there isn't a legal obligation for it. And
there isn't a legal, but every mediation organization in North America, because I chaired the committee that brought in the policy, every mediation organization requires mediators to screen. And if they don't screen, they get into trouble. There were a couple of mediators who didn't screen in the States, and clients were killed, and they were subject, probably to some type of process.
okay, so I'm saying, as you go through the line, there's the arbitration, there's the mediation, and then there's the cases that don't fall within mediation, which could be your standard negotiated resolution. It could be a court action. It could be a collaborative family law matter where there is not a mandated obligation to screen for domestic violence. Not
under the legislation, because of course all of these professional bodies are not, they are. Their organizations, community organizations, are not under the rule of the Attorney General's office. But the collaborative lawyers now, I believe, are just about to announce, if they haven't already, a domestic violence policy. It's been a long time coming. It's been something that's been missing, because I've got some experience with this. Because in a collaborative process, if people don't reach an agreement, the professionals are fired. All the professionals have to withdraw, and people have to go and hire new people. And as a result, there can be considerable pressure on vulnerable participants to agree to something so that the professionals don't get fired. And I'm an editor for one of the family law journals, and one of the articles that I reviewed showed that in those kinds of situations, vulnerable people, usually women, feel very much pressured to make decisions they don't think are in their best interest, because the professionals don't want the process to end. So I worry about that. And I think that there absolutely has to be screening, because, in fact, there's a conflict of interest. There's a conflict of interest. The lawyers want the process to succeed in the best interest of their clients. But if they don't know that there's domestic violence, then they may not act in the best interest.
Well, I think that goes into power and control, because I'm probably a little more reluctant as a collaborative lawyer to take as many cases in the collaborative forum as other lawyers. I know some lawyers will say almost every case fits collaborative, and I like to look at a collaborative case that there has to be a pretty similar bargaining power for me to want to bring my client into that process. Because my experience, both as a lawyer in the process and as a lawyer that has seen cases coming out of the process with people with the deals that they don't like, is that they feel that pressure to sign, and they feel that pressure to potentially do a bad deal. And it may not be over domestic violence. It may be a financial pressure that I've invested all this money in this process and I don't want to start over. So I'm very reluctant, if I think my client is in a much weaker position, to go into the collaborative process. Now, that's not to say I haven't had cases where I'll say, let's negotiate as if it was a collaborative file, but I don't want to sign the participation agreement that means you have to withdraw. And I think that helps deal with that.
Yeah. I think that you could expand the number of clients you could take in a collaborative process if you understood what the nature of the imbalance was, because my experience is lawyers the last to know. I find that lawyers are reluctant to ask their clients about things they don't want to know about their clients. And as a result, they're often not aware of what pressures the clients are under. Or it may be that they think they're prying, or they think they're asking questions that are irrelevant. but it may well be that a client is under the pressure of an extended family member who's paying for the process, or they're under the pressure of a spouse, or they are fearful of being excluded from their religion, their faith community, or their cultural community. And if we don't understand the pressures, or they are afraid that if they take too hard a line on something, they won't get support, or their immigration situation will be compromised. So I think that it's very important for lawyers to understand their situation and then be able to be helpful to them, to advise them, knowing what the situation is. Yeah.
Well, it creates a fascinating situation from an academic perspective, but I think back to where the client comes from. And I know from taking your course, what does screening for domestic violence look like? Because there may be a statutory obligation for arbitration. However, no one has spelled out what is screening for domestic violence.
Okay. So first of all, it's a separate screening. You don't screen with both people in the room because, of course, you're raising, you can't ask the same kinds of questions. So you have to have a private conversation. You have to make sure that that you tell the client that the conversation will be confidential and that you will be meeting with both clients and that confidentiality will apply to both. And you also need to caution them that at the time of separation, often feeling too high, where things may get out of control that wouldn't at other times have gotten out of control, and that your concern is for the well-being of everybody in the family, that you're concerned that if things escalate, it's in nobody's interest. So you kind of give that kind of preamble. And then what you do in your screening is, first of all, many of the people who are either victims or perpetrators have come from families where that was the norm. That was the kind of experience that they've had. I've often been very surprised at people who look perfectly wonderful as they come in the room. Maybe even I'm a little intimidated by how strong and together they look. But in fact, they've been in some pretty difficult situations. They tend to be acting with those kinds of experiences in their mind. So you need to find out a little bit about the family history and whether issues of alcohol abuse, domestic violence, mental health are factors. You then need to get some idea about the history of the relationship. In many cases, there have been incidents of domestic violence before people committed to the relationship, and they think that it will go away. Another important factor is that many of the occasions of domestic violence happen when somebody is pregnant. Huge number of domestic violence cases are when somebody's pregnant. Often, and by the way, there are more in common law relationships than there are more cases of domestic violence in common law relationships than in marriage relationships. Often that could be a time that people feel trapped. They can't get out of the relationship. Whatever the trigger is, you need to know some of the things that might have triggered an abusive relationship and find out how that person dealt with it. When someone's pregnant, often they get the message from their family, you made the bed, you've got to sleep in it. And it's, you don't share your dirty linen elsewhere. And you also need to know issues around control. Is this a person who's not really permitted to speak to their family members, or they're not permitted to see their friends, or they can't go out to work? They're basically monitored. They're driven to work, they're dropped off, they're picked up. What level of isolation has that person got? And there are far more women in rural situations who are in abusive relationships than the city because they are more dependent. So you want to find out about whether they're
I think we're having some technical difficulties.
Other support network with them and all that. Sorry, I couldn't hear that.
We had some technical difficulties. You were frozen for a bit, but we did have a question that came in while you were answering that question. The first question was, how should a lawyer deal with a client that they suspect is abusive?
They said is the abuser?
Yes.
Okay. Well, I think that's a really good question. I'm glad that that somebody is asking that. I think that I want to show empathy to both abusers and to victims, because often abusers are people who've been in abusive homes. And so I want to find out, and often abusers think that they're better than the parent who abused them or who demonstrated abuse in front of them. They think they've improved. So I want to have a conversation with them to find out a little bit about the nature of what led up to the separation, to ask them, usually they're the one unhappy about the separation, ask them a little bit about what it is that made them unhappy, see if they've got any ability, any capacity to understand why the other person might have made the decision that they made, find out a little bit about what their objectives are, which usually going forward are, number one, to get the person to reconcile, which I think you need a conversation about telling somebody that pursuing that objective at this time may not be in their interest. Because if somebody were to decide to reconcile down the line, it would be because they didn't feel under pressure. So helping them get a little perspective. Another one is to talk to them about the fact that even if that first goal is not met, they very often want a goal of being able to get along well enough to maintain a relationship with their children. So I talk to them about how they might get some support in communicating with their spouse in a way that would make it more likely that they could achieve a secondary objective. Maybe not perfect, but I say many people can end up being parenting partners who have not been able to succeed in maintaining the marriage, but let's look at some sub goals. And then what might they do in order to work on those skills? So then I try to get them into some form of counseling and some ability to look at their behavior. And if I think they're going to abuse again, what I talk to them about or ask them to reflect on is, if you control, what would happen then to you and help you achieve some of your goals? So I put some cautions in place.
Well, you have to understand too, I think that Dr. Landau is talking about this from the perspective of a mediator. I look at it from the perspective of a lawyer. And when my client goes to mediation or mediation arbitration, I like to do the screening myself for domestic violence. I know that Dr. Landau probably disagrees with me on that.
No, I completely agree.
Okay, I thought you might have disagreed, but I prefer to
No, 100%. We have an agreement.
Okay, that's good, because in our classes, we haven't always agreed on certain things. And
right.
When I look at the screening for domestic violence, I found it very helpful when I do it. It gives me a greater understanding of what my client is looking at, what my client is going through. And when you are meeting with the abuser, they're also going to frame things very differently than their former spouse. They're typically going to minimize what took place. Usually it took place a long time ago, and usually there were external circumstances that caused their stress to be unbelievable at the time. And you have to deal with it, and you have to frame it and say, if we're going into a mediation, it may be perfectly safe for the other client to be there, especially if their lawyers are there. You may need security. You may not want them in the same room at a mediation. But at the end of the day, sometimes you can do a lot better at that mediation, acknowledging, yes, it took place. I made a mistake. I was wrong. I'm sorry. I want to move forward. And the person who is the victim usually feels much better when they see that that other person was apologetic with moving forward and co-parenting.
Absolutely.
Because they see there was an acknowledgement of what took place, and that becomes an important part of it.
I think that's another wonderful reason why you doing the screening is so important, because then you're able to help your client be more helpful to themselves. I think that's excellent. So I know that another thing that may be important is,
unfortunately, we're having more technical.
ADI is an out-of-court process.
I think we're having some more technical difficulties, but I do see that we got another question. I apologize as I lean forward because my eyes aren't as good at seeing the question. But what are the benefits of
exactly what I just said? It's what I just said.
Processing by ADR than by litigation.
So
you can answer it, Dr. Landau.
Okay, so for me, the first benefit is there is no screening for domestic violence in the courts. The screening, and it isn't a private situation. You're putting your evidence out, and the incidents of people getting killed are almost never coming out of mediation, but they are coming out of litigation. The domestic violence cases where people have gone to court, and a lot of the cases that go to court, you end up having to write affidavits about what the other person did that was so harmful. And those are public documents, and they often trigger domestic violence. So those are the things that create obstacles. For me, the best thing about ADR is if the mediator understands both parties' situations and can design a process that's safe. So, for example, you mentioned that maybe they won't be in the same room, maybe they will. Maybe they won't be in the same room initially, but then maybe they'll gradually, as there's an acknowledgement and apology, be together. Maybe one person arrives first, okay, so that you have the abuser arrive first, quotes, abuser, so that they can't stalk the other person and threaten them coming in the door. And you have them wait afterwards so that the other person can leave safely. You may have a co-mediator. You may have a support person. You can design the process in ways that address the particular needs of that person. It's also an opportunity, like litigation is based on making your case against the other person. That's not the purpose of mediation at all. The purpose is to find common ground and to arrive at a solution that will last, that will be sustainable, that will be safe, that will be reasonable. And the focus is good for the kids, something that will be good for the kids. And for most children, it's good to have a relationship with both parents, but not if a parent is continuing to hang on to an abusive pattern of behavior. So you have an opportunity over a period of weeks to monitor, to say, why don't we try X or Y and see what happens? See whether the kinds of commitments that the survivor of abuse, I prefer survivor to victim, that they need in order to feel secure. Can you agree not to make threatening phone calls? Can you agree not to show up in the middle of the night and put your headlights on the bedroom window and, whatever the threatening kinds of things that they may be doing? Can you agree to follow whatever interim plan you've worked out? And let's see how it works out, and let's see how the kids react. You have a chance to do trial and error and improve. And I love it. So I find very few cases that I need to reject, particularly if I understand the dynamics and I can modify the process accordingly.
Well, one of the nicest things I find, and I put on my hat when I do mediation in this one, is when I am caucusing with both sides. In mediation, I can sit there and say to somebody, I understand why you feel that way. I sympathize why. I appreciate it. I can say the challenge we have is the legal model may not support your feelings, but I do understand why. And that can be really important for someone to have been heard. And in a court,
I think that's excellent.
It's much harder to get heard in a court setting. In a mediation, you can feel that you've been heard, and then I find it a lot easier for people to move on to a resolution when they feel that they've been heard, whether you agree with it or not.
I totally agree. I know. And I think that's the difference. You can understand without agreeing. You don't need to agree with people as a mediator. There's lots of room to understand, to demonstrate your understanding, but then you will respond, and not to respond in an aggressive, adversarial way, but in an appreciative way. Thank you for that. Maybe, and I would also like, for example, in mediation, when I have people that are high conflict, once I've met with them a few times, I often give them the homework of coming in the door saying something that they observed that was good that the other person did, or something that they did or said that you appreciated, something that made you feel that there was a positive prospect for your agreement. It's amazing when people say a positive thing. They're not used to hearing positive things. When they hear something positive, they often respond very, very well, and that settles them down. So good. That all of those are really good skills and abilities or reasons to try an alternative dispute resolution process, which isn't alternative anymore.
Well,
Yeah.
I agree with that comment. The other thing, I wanted to circle back to a statement you made earlier,
Sure.
which had to do with the fact that in rural settings, people try, and even in urban, people try to focus on where their former spouse is and monitor where they go. And one of the things I've seen more and more as a problem are things like Find My iPhone and apps that allow someone to track where they can say, I'm not doing anything nefarious. That's what we did when we were separated. And the other spouse doesn't even know it's happening, that their former spouse is seeing exactly where they go, especially if that person is very jealous, and that can create a dangerous situation. And
you're absolutely right. And I have a number of clients where that, and they monitor, even they track the mileage. They find ways of looking at visa bills, whatever. Yeah.
Well, you know, the thing that I've always said is if somebody wants to know or ask my kids, what did you do with their dad this weekend? I don't think most parents really care. The child says, oh, we went to this person's house or that person's house. But there's just something that feels real creepy to most people to know somebody could be sitting at home on their phone or their computer and watching a map with the dot moving along, showing where they're going. You know, that really is Big Brother watching. And I get why.
It feels frightening.
And
some been followed. They're even followed, and with the idea of moving them into a ditch or into a dangerous situation.
So I've had clients say to me, Andrew, we have a real problem with this. And I tell them, turn it off. Just simply turn that feature off on your phone. Some of them are very nervous about the repercussions that they're going to get when their former spouse says, I saw you turned it off. Why are you turning it off? What are you doing? And that's usually when they're still in the same home, because that's where the fear really is much more when they're in the same home. So technology on one hand can be a wonderful thing, but it can also be a real problem. And to those of you who may be watching this for a friend or something like that, you may even want to think for yourself, do I necessarily want to give my spouse the ability to find my iPhone? Maybe I should just keep it isolated to myself and not give that out, because one day I may not like it.
If you're concerned about stalking, which by the way is a male behavior, there's almost no women that talk. There was a good movie but talk about it.
Well, I think we had some technical problems with what you said there, Dr. Landau, but what I'll try and reiterate it. Basically, I think you said that stalking is really men that do it and women don't do it for the most part. There's always,
rarely. Rarely, yeah.
It's one of those things that you have to think about. And I know in the form that I use with screening for domestic violence, and now that I'm talking to you about this, I'm actually thinking I should amend the questionnaire that I do to put that on the questionnaire.
I think that's excellent. I think that's excellent, especially because men, and I'm going to be generalizing again, tend to be more technologically oriented. You know, I'm certainly not a technology expert, that's for sure. And so I wouldn't likely be able to do that to somebody else, but they might be able to do it to me. I think it's something worth talking about.
Well, I tend to disagree with you on that. I disagree that men are more technologically advanced. And I've had a number of male clients say to me over the years that their wives watch what they do with the kids on their parenting time to see where they're going. So it may not be stalking for abuse, but it may be stalking to see what the children are doing. So not the same fear, but still existing.
Okay. That's a very good point. And you know, one of the things I like to talk to parents about is that you need to focus on being the best parent you can be in your home, but you're not going to get a welcome reception to parenting in the other parent's home. So that's a very good point. Yeah.
So I see our time is up. I wanted to thank you for coming on the show today. I think it was very informative. I know I enjoyed the conversation. I want to thank our viewers for watching. And I hope that they'll be joining us on the next Ask Andrew show that'll be on in February, and we'll be promoting the date when it's been determined. Thank you for joining us today.
Thank you. It's a pleasure.